Dear learners, welcome to this session. Today we will be discussing the Juvenile Justice Care and Protection Act 2015. You know, in the earlier sessions we have discussed the definition of this act. Then we have also discussed various provisions related to this act. And today we are discussing the main provisions related to this act. So, you know, when we are talking about so many things in Juvenile Justice Act, we talk about child in need of care and protection. We talk about children, you know, who are vulnerable. There are two types of children which we have already discussed under this act. First is child in need of care and protection and child who are in conflict with law. So, you know, we were talking about the process in that how will the inquiry take place. So, inquiry by board regarding child in conflict with law. Where a child alleged to be in conflict with law is produced before the board shall hold an inquiry in accordance with the provisions of this act and may pass such orders in relation to such child as it deems fit under sections 17 and 18 of this act. So, this is a child-friendly legislation. The inquiry under this section shall be completed within a period of 4 months from the date of first production of the child before the board, unless the period is extended for a maximum period of 2 more months by the board, having regard to the circumstances of the case and after recording the reasons in writing for such extension. So, this is the beauty of this legislation, that you know you have to complete your inquiry within 4 months, and even if you want to extend it, it should not be for more than 2 months. A preliminary assessment in case of heinous offences under section 15 shall be disposed of by the board within a period of 3 months from the date of first production of the child before the board. So, in heinous cases, you know, you have a provision. If the inquiry by the board under subsection 2 for petty offences remains inconclusive, even after the extended period, the proceeding shall stand terminated. And this section is talking about the interest of the child. Provided that for serious or heinous offences, in case the board requires further extension of time for completion of inquiry, the same shall be granted by the Chief Judicial Magistrate or, as the case may be, the Metropolitan Magistrate for reasons to be recorded in writing. This is very important. We have been discussing, you know, that what are the provisions related to children who are involved in heinous or serious offences. So, here is the law on that. Then the board shall take the following steps to ensure fair and speedy inquiry. At the time of initiating the inquiry, the board shall satisfy itself that the child in conflict with law has not been subjected to any ill treatment by the police or by any other person, including a lawyer or probation officer, and take corrective steps in case of such ill treatment. This is also punishable under the same law. In all cases under the Act, the proceeding shall be conducted in simple manner as possible, and care shall be taken to ensure that the child against whom the proceedings have been instituted is giving child-friendly atmosphere during the proceedings. So, you know, it is not a court-like proceeding, it is a child-friendly proceeding. Every child brought before the board shall be given the opportunity of being heard and participate in the inquiry. Just go back to the principles. Then we have cases of petty offences shall be disposed of by the board through summary proceedings as per the procedure prescribed under the Code of Criminal Procedure. Inquiry of serious offences shall also be disposed of by the board by following the procedure for trial in summon cases under the CRPC. If inquiry is of heinous offences for child below the age of 16 years as on date of commission of an offence shall be disposed of by the board under clause E. For child above the age of 16 years, as on the date of commission of an offence, shall be dealt within the manner prescribed under section 15. Preliminary assessment into heinous offences by the board. Section 15 is very important, In case of a heinous offence alleged to have been committed by a child who has completed or is above the age of 16 years, the board shall conduct a preliminary inquiry or assessment with regard to his mental and physical capacity to commit such offences. This again talks about a child-friendly legislation. Ability to understand the consequences of the offence and the circumstances in which he allegedly committed the offence, and may pass an order in accordance with the provisions of subsection 3 of section 18. We have all cases of human trafficking which can be taken into consideration under this section, provided that for such an assessment the board may take the assistance of experienced psychologists or psychosocial workers or other experts. So this is a very child-friendly legislation wherein you can have your psychologist opinion, psychosocial workers opinion in deciding and conducting preliminary assessment. Where the board is satisfied on the preliminary assessment that the matter should be disposed of by the board, then the board shall follow the procedure as far as may be for trial in summons case under the CRPC. Provided that the order of the board is disposed of, the matter shall be appealable under subsection 2 of section 101. Provided further that the assessment under this section shall be completed within the period specified in section 14. Section 16 talks about review of pendency of inquiry. The Chief Judicial Magistrate or the Chief Metropolitan Magistrate shall review the pendency of cases of the board once in every 3 months. This talks about monitoring authority, and shall direct the board to increase the frequency of its sittings or may recommend the constitution of additional boards. So the child should not be deprived of justice, and justice delayed is justice denied. So you have a provision wherein the Chief Judicial Magistrate or Chief Metropolitan Magistrate will review the pendency of cases and act accordingly. The number of cases pending before the board, duration of such pendency, nature of pendency and reasons thereof shall be reviewed in every 6 months by a high-level committee consisting the executive chairperson of the State Legal Services Authority, who shall be the chairperson, the Home Secretary, the Secretary responsible for implementation of this Act in the state, and a representative from a voluntary or non-governmental organization to be nominated by the chairperson. The information of such pendency shall also be furnished by the board to the Chief Judicial Magistrate or the Chief Metropolitan Magistrate and the District Magistrate on quarterly basis in such form as may be prescribed by the state government. This is another child-friendly provision. Orders regarding a child not to be found in conflict with law. Where the board is satisfied on inquiry that the child brought before it has not committed any offence, then notwithstanding anything contrary contained in any other law for the time being in force, the board shall pass order to that effect. In case it appears to the board that the child referred to in subsection 1 is in need of care and protection, it may refer the child to the committee with appropriate direction. So they will see it under section 17, and if the board is convinced that he has not committed any offence, then order will be passed to that effect. If the board is convinced that he needs care and protection, then accordingly the appropriate directions will be given. The number of cases pending before the board, duration of such pendency, nature of pendency and reason thereof shall be reviewed in every 6 months by a high-level committee consisting of the executive chairperson of the State Legal Service Authority, who shall be the chairperson, the Home Secretary, the Secretary responsible for implementation of this Act in the state, and a representative from a voluntary or non-governmental organization to be nominated by the chairperson. This, we have just discussed. The information of such pendency should also be furnished by the board to the Chief Judicial Magistrate or the Chief Metropolitan Magistrate and the District Magistrate on quarterly basis in the form as may be prescribed by the state government. This is again we have already talked about. Then we have provisions that where the board is satisfied, that there are so many things which a child has to be, a child is there and is in conflict with law, then what orders need to be passed, that is dealt in section 16. Where a board is satisfied on inquiry that a child irrespective of age has committed a petty offence or a serious offence, or a child below the age of 16 years has committed a heinous offence, then notwithstanding anything contrary contained in any other law for the time being in force and based on the nature of offence, specific need for supervision or intervention, circumstances as brought out in the social investigation report and past conduct of the child, the board may, if it so thinks fit, allow a child to go home after advice and admonition by following appropriate inquiry and counselling to such child and to his parents or guardians, direct the child to playing and similar activities, order the child to perform community services under the supervision of an organization or institution or a specified person, persons or group of persons identified by the board, order the child or parents or the guardian of the child to pay fine, provided that in case the child is working, it may be ensured that the provision of any labor law for the time being in force is not violated. This talks about a child-friendly legislation. Direct the child to be released on probation of good conduct and placed under the care of parents, guardian or any fit person or such parent, guardian or fit person executing a bond with or without surety as the case may be, as the board may require for the good behavior and child's well-being for any period not exceeding 3 years. So again a child-friendly provision. Direct the child to be released on probation of good conduct and placed under the care and supervision of any fit facility for ensuring the good behavior and the child's well-being for any period not exceeding 3 years. Direct the child to be sent to a special home for such period not exceeding 3 years as it thinks fit for providing reformative services including education, skill development, counseling, behavior modification therapy, psychiatric support during the period of stay in the special home, provided that if the conduct and behavior of the child has been such that it would not be in the child's interest or in the interest of other children housed in the special home, the board may send such a child to the place of safety. So the child who is in question has to be safe and the other children who are staying in the home have to be also be safe. So both the interests will be taken into consideration while passing any order. If an order is passed under clause A to G of subsection 1, the board may in addition pass orders to attend school, attend a vocational training center, attend a therapeutic center, prohibit the child from visiting, frequenting or appearing at a specified place or undergo a de-addiction program. We have seen that the trafficked children are abused, addicted, where the board after preliminary assessment under section 15 pass an order that there is a need for trial of the said child as an adult, then the board may order transfer of the trial of the case to the children's court having jurisdiction to try such offences. Order that may not be passed against a child in conflict with law. Section 21. No child in conflict with law shall be sentenced to death or for life imprisonment without the possibility of release for any such offence either under the provisions of this Act or under the provisions of Indian Penal Code or any other law for the time being enforced. Section 23 says that no joint proceeding of a child in conflict with law and a person who is not a child can be done. So adult proceedings will be differently being done and the child will be handled differently. So joint proceedings is not allowed. Section 26 deals with provision with respect to runaway children or children who just run away and are in conflict with law. Chapter 6 talks about procedure in relation to children in need of care and protection. So we have discussed child who are in conflict with law and now we have a provision for children in need of care and protection. 31 talks about production before committee. Any child in need of care and protection may be produced before the committee by any of the following persons: any police officer or special juvenile police officer, or a designated child welfare police officer, or any officer of the district child protection unit, or inspector appointed under any labor law for the time being in force. So now you get a clue that whom to complain. You can complain to any police officer if you see any child being abused, or a special juvenile police unit, designated child welfare police officer, or any officer of the district child protection unit or inspector appointed under the labor laws. Any public servant, child line services 1098, or any voluntary or non-governmental organization or any agency as may be recognized by the state government, child welfare officer or probation officer, any social worker or a public spirited citizen. So you can also take care of that child and hand it over to the committee. By the child himself, any nurse, doctor or management of a nursing home, hospital or maternity home. So the child who is very vulnerable can also approach. The doctors, the nurses, the hospital staff can also approach, provided that the child shall be produced before the committee without any loss of time, but within a period of 24 hours excluding the time necessary for journey. This is a child friendly legislation. So within 24 hours you have to produce that child before the committee. Mandatory reporting regarding a child found separate from guardian. 32 section. Any individual or a police officer or any functionary of any organization or a nursing home or hospital or maternity home who or which finds and takes charge or is handed over a child who appears or claims to be abandoned or lost, missing children, or a child who appears or claims to be an orphan without family support, shall within 24 hours, excluding the time necessary for the journey, give information to the child line services or the nearest police station or to the child welfare committee or to the district child protection unit, or hand over the child to a child care institution registered under this act as the case may be. The information regarding a child referred to in subsection 1 shall be mandatorily uploaded on a portal as may be specified by the central government or the committee or the district child protection unit or the child care institution as the case may be. So we have a very good provision under section 32 that talks about mandatory reporting regarding children who are in need of care and protection. Surrender of children. A parent or guardian who for physical, emotional and social factors beyond their control wishes to surrender a child shall produce the child before the committee. Children are sometimes left over by their own family members. So in this case we have this section. If any prescribed process of inquiry and counseling, the committee is satisfied a surrender deed shall be executed by a parent or guardian as the case may be before the committee. The parents or guardian who surrendered the child shall be given 2 months time to reconsider their decision. A very important point. A child is safe in his family environment, and in the intervening period the committee shall either allow after due inquiry the child to be with the parents or guardian under supervision, or place the child in a specialized adoption center agency if he or she is below 6 years of age, or a children's home if the child is above 6 years of age. 36 talks about inquiry on protection of a child or receipt of a report under section 31. The committee shall hold an inquiry in such manner as may be prescribed, and the committee on its own or on the report from any person or agency as specified in subsection 2 of section 31 may pass an order to send the child to the children home or a fit facility or fit person, and for speedy social investigation by a social worker or child welfare officer or child welfare police officer, provided that all children below 6 years of age who are orphaned, surrendered or appear to be abandoned shall be placed in specialized adoption agencies where available. The social investigation shall be completed within 15 days so as to enable the committee to pass final order within 4 months of first production of the child. This is also very child friendly provision. Provided that an orphan, abandoned or surrendered children, the time for completion of inquiry shall be as specified in section 38. After the completion of the inquiry, if the committee is of the opinion that the said child has no family or sustainable support or is in continued need of care and protection, it may send the child to a specialized adoption agency if the child is below 6 years of age, children home, or to a fit facility or persons or foster family till suitable means of rehabilitation are found for the child as may be prescribed, or till the child attains the age of 18 years, provided that the situation of the child placed in a children home or with a fit facility or persons of a foster family shall be reviewed by the committee as may be prescribed. A very important provision. The committee shall submit a quarterly report on the nature of disposal of cases and pendency of the cases to district magistrate in the manner as may be prescribed for review of pendency of cases. After review under subsection 4 of the district magistrate shall direct the committee to take necessary remedial measures to address the pendency if necessary and send a report of such reviews to the state government, who may cause the constitution of additional committees if required. So, if this provision is working properly, implemented properly, then we do not have cases of child abuse, of child trafficking. Provided if the pendency of cases continues to be unaddressed by the committee, even after 3 months of receiving such direction, the state government shall terminate the said committee and shall constitute a new committee. A very proactive section. Section 37 talks about order passed regarding a child in need of care and protection. The committee, on being satisfied through the inquiry that the child before the committee is a child in need of care and protection, may, on consideration of social investigation report submitted by the child welfare officer and taken into account the child's wishes in the case the child is sufficiently mature to take a view, pass one or more of the following orders, namely declaration that the child is in need of care and protection so that he gets the benefit under this act, restoration of a child to parents or guardian or family with or without supervision of child welfare officer or designated social worker, placement of the child in children home or fit facility or specialized adoption agency, children below 6 years of age, for the purpose of adoption for long term or temporary care, keeping in mind the capacity of the institution for housing such children, either after reaching the conclusion that the family of the child cannot be traced, or even if traced, restoration of the child to the family is not in the best interest of the child. Placement of the child with fit person for long term or temporary care, foster care orders under section 44, sponsorship orders under section 45, directions to persons or institutions or facilities in whose care the child is placed regarding care, protection and rehabilitation of the child, including directions relating to immediate shelter and services such as medical attention, psychiatric and psychological support, including needs-based counseling, occupational therapy, behavior modification therapy, skill training, legal aid, educational services and other developmental activities as required, as well as follow-up and coordination with the district child protection unit or state government and other agencies. Declaration that the child is legally free for adoption under section 38. The committee may also pass orders for declaration of fit person for foster care, getting aftercare support under section 46 of the Act, or any other order related to any other functions as may be prescribed. Chapter 7 deals with rehabilitation and social integration of children who are in need of care and protection. Chapter 8 deals with adoption. Chapter 9 deals with the other offences related to children. So in the end, I will just like to say that if we have the law implemented properly, then we will not have cases of human trafficking of children for labor, for organ, for drugs, for domestic help, for pornography or for any other form of trafficking. So it is just that we don't know about the law and the laws are not implemented properly at the grassroots level and we do not act as informed citizenry. So I hope you have understood this legislation. Thank you for listening. Stay blessed.